Hello everyone, my name is Jackson. Today my group members and I will be discussing on the laws protecting children, specifically from sexual offences and their satisfactions in Malaysia. In Malaysia, the laws that govern sexual offences against children are the Child Act 2001, the Sexual Offences Against Children Act 2017, and the Penal Code. The Child Act 2001 consolidates the law relating to the care, protection, and rehabilitation of children. It seeks to safeguard the interests of children who are at risk. This can be seen as under Section 17 of the Child Act. The child will be deemed to need care and protection if one of the subsections as shown on the slides is satisfied. The Act also provides provisions that imposes restrictions on media publications and reporting in order to protect the interests and welfare of the child. Under Section 15, any mass media report regarding any child in respect of whom custody is taken under Part 5 of the Child Act shall not reveal the name, address, or educational institution, or include any particulars calculated to lead to the identification of any child so concerned, written as being the person against or in respect of whom action is taken, or as being a witness to the action. The picture of any child concerned or any other person, place, or thing which may lead to the identification of any child concerned also shall not be published in any newspaper or magazine or transmitted through any electronic medium. Furthermore, Section 18 of the Act imposes duty of protector or police officer taking a child into temporary custody. If the protector or police officer is satisfied on reasonable grounds that the child is in need of care and protection, they may take the child into temporary custody. The duty to inform is imposed to medical officer and member of the family under the Act. According to Section 27 and Section 28, if the respective parties who believes on reasonable grounds that the child he is examining or treating is physically or emotionally injured as a result of being ill-treated, neglected, abandoned or exposed, or is sexually abused, shall immediately inform about the abuse. Such duty is also imposed to the child care provider under Section 29. The Sexual Offences Against Children Act 2017, or in short, SOACA, was introduced to address the seriousness of sexual offences committed against children in Malaysia. Child grooming occurs. Under the Act, child grooming occurs when an adult befriends a child and creates an emotional connection with the intent to sexually abuse the child. Protections are broken up into 3 sections, roughly summarized as communication, grooming, and meeting in person. Section 11 prohibits any form of sexual communication with a child or encouraging a child to have a sexual communication unless that it was for purpose of science, medicine, or education as states under subsection 3. Section 12 makes it illegal to communicate or pretend to be someone else to sexually communicate with a child, even if they never actually meet in person. This also includes communication for the reasons stated in Section 5, 7, 8, 14, and 15. Whereas Section 13 describes the situation when the adult meets up with a child. Basically, it's a type of communication mentioned in Section 12, plus actually taking steps to meet the child. In short, with regards to the 3 sections mentioned, a child is being protected from sexual grooming. Thank you.
My name is Jawan and I'll be continuing off Jackson. Protection provided to children specifically from sexual offences are considered satisfactory. This is because one cannot be involved in child pornography in any way. Under Section 4, Subsection A, a wide definition of child pornography is provided as shown in these slides. This definition shows its satisfaction as it brings a broader meaning that the law doesn't just include a child engaged in sexual activities, but someone appearing to be or portraying a child as well. Besides, This act is satisfactory as it protects children from involvement of making of child pornography. Regarding Section 5, any form of involvement in making of child pornography is prohibited, whereas using a child to produce child pornography is prohibited under Section 7. Regarding distribution and reproduction of child pornography, Section 8 provides a list of examples of activities which if a person has knowledge or reason to believe is related to any child pornography shall be punished as seen in this slide. By including this section, the law also covers people who participate in or make an income from a child pornography-related business besides of stopping people from distributing and reproducing child pornography. Furthermore, one cannot access or watch child pornography. This is supported under Section 10, which demonstrates any person who with access or possession or control of child pornography shall be liable. This means that if you knowingly visit a website containing child pornography, you are obviously guilty of an offense under Section 10. In short, with regards to the sections mentioned above, one cannot be involved in child pornography. This therefore protects children from involvement of child pornography effectively. With passing of SOACA, sexual assault can also be non-physically instead of just physically. Section 14 covers physical sexual assault on minors, which involves not just touching a child but also in getting a child to touch you, someone else, or even themselves. An example is seen where a man who allegedly sodomized and raped his daughter 600 times was charged under Section 14 as reported by New Straits Times. With regards to non-physical sexual assault of children, Section 15 illustrates that non-physical sexual assault is where an adult exposes a child to sexual or indecent situation. This situation can be roughly summarized as any lewd sounds, gesture, or exposed body parts that is intended to be seen or heard by the child, exhibiting the child's body to others, constantly following, watching, or contacting a child, or showing or involving a child in something that's sexual, including watching porn. Thus, even there's no physical sexual assault, an issue may be raised under Section 15 once there is an act to a child that incurs the mentioned sexual or indecent situation. Besides, there are many sexual abuse cases against children carried out by a person that they trust, such as a guardian, parent, or teacher. This is further assisted by Section 16, which allows the court to sentence someone who is in a position of trust with the victim. To add perspective into how these laws apply, a stranger who sexually assaults a child will be guilty of a Section 14 offenses. However, a teacher sexually assaulted a student, the teacher will be guilty of Section 14 offenses and a Section 16 offenses. For example, a male teacher with committing sexual physical contact on a 9-year-old male student by hugging and kissing the boy in the toilet of a school was charged under Section 14 and 16. In short, this further prevents a child being involved in sexual offenses as extra punishment will be charged if there is an abuse of position of trust. An extra punishment to the abusers in position of trust shows its importance and satisfaction as seen in the tables. Children involved in sexual crimes carried out by a known person are drastically higher as compared to strangers in 2000 to 2003, and rapes carried out by a known person in 2014 and 2015 are high as well. In addition, as capacity and evidence of child witness are listed in Part 5, better approach is taken as evidences can be presented by a child. As seen in Section 17, a child is presumed to be competent to give evidence unless the court thinks otherwise. This is further supported by Section 18, which allows the court to convict such person of such offense based on the uncorroborated evidence of a child, given upon oath or otherwise. This satisfactorily gives priority for the child's statement as the child is presumed to be competent to give evidence once it is determined that the child has sufficient intelligence and understands the duty of speaking the truth. In short, through the satisfactions as discussed, SOACA is satisfactory.
Hello, my name is Saw Shanice and I will be discussing on the flaws of the laws. The Penal Code and the Child's Act 2001 do not adequately protect children. Therefore, the government has enforced SOACA to protect underage children in the country from harm, especially from sexual crimes, as my good mate has stated earlier. However, there are some loopholes towards the new statute. Firstly, the SOACA did not touch on child marriages. Recently, the Sharia Judiciary Department revealed that a total of 10,240 child marriages among Muslims were recorded from 2005 to 2015. As for non-Muslim, the National Registration Department revealed that a total of 2,400 girls were married at the age of 16 over the span of 5 years from 2011 to 2015. Section 8 of the Malaysian Islamic Family Law clearly states that the minimum legal age for Muslim boys to marry is 18 years old, while for Muslim girls is 16. While younger couples are allowed to marry with written permission from the Sharia court after both sets of parents have put in an application to formalize their marriage. As for non-Muslims, the legal age of marriage is 18. Non-Muslim girls are permitted to marry within the ages of 16 and 18 with the consent of the Chief Minister, which is stipulated under Section 10 of the Law Reform Marriage and Divorce Act. These laws violate authoritative interpretations of the Convention on the Elimination of All Forms of Discrimination Against Women, which Malaysia has ratified. The United Nations consider the minimum legal marriage age 18, with the exception granted solely under exceptional circumstances to mature children 16 or older, which a judge authorization. Marriage before the age of 18 is a fundamental violation of human rights that impacts all aspects of children's lives, especially girls. In Malaysia and elsewhere in the world, child marriage denies girls and boys their childhood, disrupts education, limits opportunities, increases the risk of violence, and jeopardizes health. Besides that, there are several cases over the years of rapists marrying their children, including those under 18, to avoid prosecution. Marital rape is not a crime in Malaysia. While under the current law, men who marry their victim can still be prosecuted for rape committed before their marriage, which has happened in a few high-profile cases. The law makes it easier for rape to be swept under the carpet through marriage. Moreover, there is an issue relating to the age of a child. Section 2, subsection 1 of the SOACA provides that the proposed act shall apply to a child who is under the age of 18 years. And by virtue of Section 2, subsection 2, any reference to a child shall include a person whom the accused for an offence under the proposed act believes is if a person under the age of 18 years. The issue is the application of the proposed act to those who actually abuse children. The addition of Section 2, subsection 2 contradicts Section 2, subsection 1 and could allow perpetrators above the age of 18 years to escape prosecution. Not only that, how far and wide the net has been cast with the definition of physical sexual assault in Section 14 of the SOACA and the need to make police report by anyone in Section 19 and its implications. As the statute stands in its current form, all physical contact of sexual in nature, irregardless of whether sexual intercourse has been taken place, is an offence involving anyone below 18 years old, and everyone who have knowledge of such an offence, including healthcare professionals, need to make a police report. This creates a situation whereby any physical contact in a consensual relationship in our youth is an offence as long as one partner is below 18 years old. Lastly, SOACA is lacking of a comprehensive sexuality education within the legal frameworks. International agreements over the past decade, such as the International Conference on Population and Development in 1994, the Fourth World Conference on Women in 1995, and the World Summit on Children in 2002 have extended the scope of the Convention on the Rights of a Child by affirming the right of all children to receive sexual and reproductive health information, education, and services in accordance with their specific needs. Annually, there are 13,000 to 17,000 teenagers that have been pregnant, and the 5th Malaysian Population and Family Survey in 2004 has shown that 2.3% of our 13 to 17-year-old are already sexually active with very poor sexual and reproductive health knowledge.
Hello, my name is Jazrin Harith bin Jeffrey, and I will be explaining on the Malaysian Penal Code. It is absolutely essential for the criminal law to protect children from sexual abuse and exploitation. While much of the media focus is on high-profile cases where children are raped or abducted by adults, the sad truth is that male and female children are far more commonly the victims of abuse, both physical and sexual, at the hands of family members or adults in relationships of trust. As international travel and the internet have blossomed, so have the opportunities for child abuse and the need for a firm legal response. The Malaysian Penal Code has few offences specifically designed to protect children and tends to rely on the offences of general application. In Malaysia, sexual offences against children are primarily dealt with through the offences of general application. The main options under the Malaysian Penal Code are as follows. If a man penetrates the vagina of a female under 16 years old with his penis, the offence is rape under Section 375G, irrespective of any suggested consent. Under Section 377A, if a man has sexual connection with a male or a female child by introducing his penis into the child's anus or mouth, he commits the offence of carnal intercourse against the order of nature, irrespective of any suggested consent. Under Section 377CA, it is an offence for any person or female to introduce any object into the vagina or anus of another without consent. However, for this offence, it appears that the prosecution must prove absence of consent except where the child is under 12 years old of age. It may also be noted that the word object does not appear to include parts of the body. In the case of Bunia, a 60-year-old man was convicted of rape by using his finger. A Sarawak State Minister has urged the federal government to amend the penal code to allow a wider scope for the definition of rape, following a 60-year-old man's acquittal of raping a minor. A State Welfare, Women and Family Development Minister, Dr. Fatimah Abdullah, said that the current definition of rape is confined to penile penetration and does not consider the use of any other body parts or objects as contributing to the offence. She also urged parliamentarians to echo the call and push for amendment so that there won't be a repeat of this finger rape loophole, which did not constitute penetration under the current definition. Next, the offence of assault with intent to outrage modesty under Section 354 will apply to sexual touching falling short of the forms of penetration covered by other offences. However, here again it will be necessary to prove absence of consent unless the child is under 12 years old of age. Incest under 376A may be a potential charge if one of the specified relationship exists. However, the offence is limited to sexual intercourse and does not cover other forms of intrafamilial abuse. Offences relating to gross indecency, Section 377D and 377E may apply. These offences can be committed irrespective of consent, and inciting a child commit to an act of gross indecency also carries a higher maximum penalty. Where the victim suffers bodily pain or disease or injury as a result of sexual abuse, the offence of voluntarily causing hurt may apply. Importantly, the law provides that the age of consent for the purpose of hurt offences is 18 years old. In conclusion, Malaysian laws are not satisfactory in protecting the children who are the victims of sexual abuse. Therefore, reforms should be made to the laws that are available. For instance, the Penal Code should be more clear in defining the definition of rape, where currently the definition is quite vague. On top of that, Other laws which include SOACA 2017 and Children Act 2001 also need to be under the spotlight of the Parliament and should be repealed from time to time. Teo Ning Ching, DAP Kulai, cited 2 cases of the victims marrying their attackers and argued that the marriages ended up being more problematic and causing more hurt. Teo's motion to amend the Sexual Offences Against Children Bill to include child marriage as an offence was ultimately defeated by a voice vote. The government should address child marriage in this country under SOACA. The government should consider this proposal, meet agencies on the issue, and find ways to protect the interests and safety of our children. After the Sexual Offences Against Children Act 2017 was introduced, an open letter was submitted to the Parliament. Comprehensive sexuality education, which includes pregnancy prevention methods teachings, as versus abstinence-based sexuality education, will now be more challenging to deliver, and access to sexual and reproductive health services made more difficult in the current criminalization of consensual relationships in young couples. We need to provide our teenagers with comprehensive sexuality education, including knowledge about pregnancy prevention methods and access to contraceptives for those who are already sexually active. This is not to encourage them, but to create a more responsible youth. Comprehensive sexuality education shall then be inserted in the Malaysia's education system. Lastly, government of the day plays a vital role in creating policies and should work hand in hand with the Malaysian Commission of Human Rights. Recently, the Commission expressed their strongest objection on the latest case of child marriage in Kelantan. This commission should be pressuring the government on the human rights of the children so that the matter can be further discussed in Parliament. Thank you.